First of all, I wish to extend my gratitude for the invitation and the organizers, Women's Cell and ICC, AMU Center Malappuram, and DLSA Manjeri in association with LJRF Center for Women and Children. Thank you for the invitation. So, before starting, I would like to extend my gratitude to all the students who have joined here, and I hope that I will be I am able to provide my best knowledge for enlightening you all in this topic. So, without any extension, I would like to start. So, as we all know, the participation of women in the work environment and the workspace. So, women constitute nearly one half of the global population, and studies relating to that shows very extrinsically that a female workplace participation results in faster economic growth. So, as we all know, I can see a lot of women participants over here. So, women participation in the workspace can result in emerging growth in the economy as well. So, therefore, it's a good idea for women to enhance their presence and contribution to workspaces. But, however, a significant roadblock to increase in the effective workplace participation of women is the issue of sexual harassment. So we all know there are a lot of issues happening in the workplaces which blocks the women participation in the workspaces. So sexual harassment is one of the basic issues that that increases the absence of women in the workspace. So we know there is an Indian law which deals with this. The legislation's name is Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. So from your brochure, I came to know that the how this enactment came, what were the judgments which led to the enactment of this legislation. So I'm not going into depth with all that. So I'm just mentioning that Vishaga judgment is one of the landmark judgment which gave rise to the legislation of sexual harassment of women at workplace. So before starting or going into depth, I would like to explain the aspects of sexual harassment at workplace. So sexual harassment may be described as a discrimination, exploitation based upon sex. And it can be any unwelcome, unwarranted conduct of sexual nature. And these conduct gives an effect of violating the dignity of a woman or creating a hostile, intimidating or humiliating approach to a woman. So when a woman feels insecure due to the sexual approach from a male partner or a male person in that workplace, it can be called as a sexual harassment at workplace. So this particular behavior, if it causes an offensive environment for the employees, it can be explicitly called as sexual harassment at workplace. It can be a verbal, non-verbal, physical, mental, online, offline, any mode. It can be considered as sexual harassment. And before going into the definitions of sexual harassment in the Act, I would like to give more explanation to the word or the phrase of sexual harassment. So sexual harassment may be described as a form of sexual discrimination projected through an unwelcome sexual advances. So here the phrase of unwelcome is very important. So the approach from that particular person should not be mutual or consensual. And that particular approach should cause a kind of an irritating, humiliating, hostile environment to the victim also. And this particular sexual favors and the approach from that person can be verbal, physical contact with the sexual overtones. And also, it's not essential that this approach should be direct. It can be an implied approach also, like a person saying some kind of innuendo statements or bullying, jokes. All this can be considered as a sexual harassment at workplace. So there is a case, Apparel Export Promotion Council versus AK Chopra. It's a 1999 case. So in this case, it was held that directly, indirectly, implied, which unreasonably interferes with her work, which came an effect of creating intimidating or hostile working environment for her, can be called as a sexual harassment. So from this judgment, it's very clear that the approach or the behavior can be direct, indirect, implied, and which gives an effect of a fear or a kind of apprehension to that woman, which prohibits a peaceful working environment for her. So this is a very landmark judgment in the aspect of sexual harassment at workplace. I will repeat that case law once again. So the case name is Apparel Export Promotion Council versus AK Chopra. It's a 1999 case, Supreme Court case. So I hope that the things which I have mentioned as of now is clear for you all. If you have any doubt, you can ask.
Ma'am, can you please repeat the name of that case?
Sure. The case name is Apparel Export Promotion Council. Apparel Export Promotion Council versus AK Chopra. So once again, I will give a summarized version of what all I said as of now. I have given a definition or an explanation to the phrase of sexual harassment at workplace. So I haven't gone to the aspects or the provisions of this legislation. I have given a mere definition. So sexual harassment can be a direct, indirect, implied, or any kind of approach which have a sexual overtone and which creates an environment where that particular victim is not feeling safe to work. So this is the basic explanation to sexual harassment. So there is another case. The case name is Pankaj Kumar versus Union of India. It's a repetition case, case number 408/2013. I will repeat the case name once again. Pankaj Kumar versus Union of India. So in this case, Tripura High Court described sexual harassment at workplace. That the phrase of sexual harassment at workplace was defined by Tripura High Court in the case of Pankaj Kumar versus Union of India. So it's a 2013 case. So in this case, Tripura High Court explicitly defined the phrase of sexual harassment at workplace. So Tripura High Court gave a definition as it's an unusual conduct or behavior to a woman employee at the workplace which is not generally expected, and that behavior was because of the fact that the victim was a woman. So you all please listen. Two aspects are very important. First one is the woman or the conduct by that particular person or the respondent or the accused should be unwelcomed, and also this behavior should have happened just because that victim was a woman. Okay, so these two aspects are very important, and this definition was given by the Tripura High Court. And we all know there is no clear-cut, dry formula to ascertain what amounts to sexual harassment. But the general accepted position is that the particular behavior from that person should be related to sex, and that particular behavior should be intimidating, coercing, humiliating, and that can be also a hostile behavior. And also this particular behavior should be unwelcome, not mutual. Unwelcomed in the sense it should not be mutual. So these three aspects are the basic accepted position to ascertain the sexual harassment. So I will repeat once again. It should be, the particular behavior should be about sex. And second one is it should be intimidating, which means that it should cause fear in the victim, and that will lead to the unpleasant environment where that victim will feel irritated or unsafe to work. So the work environment should be disturbed. And the third aspect is that this particular behavior should be unwelcomed, which means that it should not be mutual. So these are the three aspects of the dry formula to ascertain the occurrence of a sexual harassment in the workplace. So before going deep into the sexual harassment's further aspects, it's very important to know about the definition of workplace under the legislation, that is under section 2 clause O. of the Sexual Harassment of Women and Workplace Prevention, Prohibition and Redressal Act of 2013. So Section 2 Clause O of the particular legislation gives a definition to workplace. So a workplace can be defined as, do you think that this particular legislation is applicable to the government organizations only? No. So we all know Section 2, once again I'll repeat the provision. Section 2 Clause O of the Act defines workplace. So it can either be a government organization, a private sector organization, a hospital, educational institute, sports institute. It can be anything where work is happening. So Section 2 Clause O details the places which can be considered as workplace. So the first one is a government organization which is funded by government. Next is, it can be a private sector organization. It can be a hospital, nursing home, etc. A sports institute. Then any place, the transportation places which visits by the employees, which is the part of the cost of employment, which means that if I'm an employee, so I have to go and visit other places as part of my job. So if I'm going and visiting those places, but I'm not sitting in my office, so due to the cost of employment or part of my employment, I'm visiting many other places. So that transportation or the visits, if an abuse or a sexual harassment happens to me during the transportation or the place visits, can also be considered as sexual harassment. So that is defined, or that is also mentioned under Section 2 Clause O. And a dwelling place or house, which means that the place where I reside as a part of my employment, that can also be considered as a workplace. And also an unorganized sector. So all these, which means that each and every workplace or an institute, organization comes under this definition of Section 2 Clause O, which defines workplace. So I hope that, once again I'll repeat, every kind of organization, whether it's government, private, unorganized sector, hospitals, educational institute, sports institute, anything comes under the definition of workplace. So it's very, very, very important to know the definition of workplace, because many women who face such kind of the harassment, sexual harassments from the office, they think that it's not possible for them to make a complaint because they are working in an unorganized sector, any small NGOs, private sectors. But that's not a mandate under the section. Any person who faces sexual harassment at the workplace can file a complaint. Okay. So next is we will go into the provisions. So the provisions which describes sexual harassment, the phrase of sexual harassment, there are two important provisions. First is Section 2 Clause N, 2 Clause N and Section 3. So Section 2 Clause N and Section 3 of the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013 talks about sexual harassment. So Section 2 Clause N defines sexual harassment. So some implications are provided under this particular section. The first one is a physical contact or advances. If a person is raising any kind of physical contact which gives an apprehension or an intimidation to the victim, can be considered as sexual harassment. So Section 2 Clause N, the first point talks about physical contact. Second is the demand of sexual favors. If a superior person or a superior authority is asking the subordinate to do any sexual favors, that can also be considered as a sexual harassment. So we will go more deep into this under Section 3 Clause 2 of the Act, which talks about the corresponding factors. So Section 2 Clause N talks about the primary factors. So first we have gone through the physical contact. Second one is request for sexual favors, and third one is sexually colored remarks. So if any person is providing any kind of statement which consists of any sexual innuendos, that can be also considered as a sexual harassment. And fourth one is showing pornography, and fifth one is unwelcome physical, verbal, non-verbal contact of sexual nature. So all these are considered as a sexual harassment under Section 2 Clause N of the Act. So section 2 clause N, again I'm repeating, section 2 clause N defines the sexual harassment. So the first one is physical contact. Second one is making any request or demand for sexual favors. And third one is making any sexually colored remarks. And fourth one is showing pornography. And fifth one is unwelcome physical, verbal or non-verbal conduct of sexual nature. So this is about the section 2 clause N, which provides the primary factors. We will go deep into what is primary and what is second, what is corresponding factors. So section 2 clause N talks about primary factors. So that I have already mentioned. Next, section 3 clause 2 of the Act talks about corresponding factors. So 4 to 5 points are mentioned under section 3 clause 2, which gives the corresponding factors. That is, if a person, implied or explicit, makes any promise of preferential treatment in her employment. For example, if my subordinate, if my superior authority is promising me that he will give me salary rise, he will give me a promotion. So if in favor of some sexual desires, or in request of some sexual favors, he is asking me, he is promising me that he will give me a promotion or a salary hike, so that I have to give some sexual favors. That is also a sexual harassment under section 3 clause 2. Next is implied or explicit threat of determinantal treatment in her employment, which means that if I am not doing any sexual favors, he will terminate me, he will suspend me. So that is also a kind of sexual harassment. And third aspect is that implied or explicit threat about her present or future employment status, that a person or my superior authority is threatening me in a way that he will not give me a safe place in the safe workplace, or a promotion, or any kind of improvements in the work aspect in future. That can also be considered as a sexual harassment. And fourth one is that making any hostile or intimidating environment which causes any kind of fear or an unsafe place for the work, that can be also considered as a sexual harassment. And humiliating treatment. So if a person is making any bullying statement, humiliating statements, that can be considered as sexual harassment. So all these corresponding factors are mentioned under section 3 clause 2 of the Act. So I have mentioned it many times, that primary factor and secondary corresponding factor. So I will explain that. So in the scope of definition analysis, this Act gives two provisions which deals or defines sexual harassment. That is section 2 clause N and section 3 clause 2. So section 3 clause N, as I mentioned, it gives a detailed 1, 2, 3 factors which mentions the contexts or behaviors which constitute sexual harassment. That is any kind of physical contact, then a demand for sexual favor. Third one is sexually colored remarks showing pornography, and the verbal, non-verbal kind of things. So all these are enlisted in the provision of section 2 clause N. This is the primary factor. And the secondary or the corresponding factor under section 3 clause 2 of the Act talks about the implied or explicit promises which is provided by the superior authority for the preferential treatment in her employment, which means that a person is giving or promising to the woman victim that he will provide her a salary hike or any kind of preferential treatment, which means an improved treatment in her workplace, so that she should do any sexual favors to him. So any kind of act, so the Act already enlisted some behaviors under section 2 clause N, but also this Act is providing for the circumstances or the corresponding factors which can be considered as a sexual harassment. So that is mentioned under section 2 clause 3 clause 2 of the Act. So next is any kind of threat or any kind of intimidating factor or a factor which makes her feel hostile or a humiliating treatment. All this can be considered as a sexual harassment under section 2 clause 3 clause 2 of the Act. So generally, provision section 2 clause n and section 3 are general, and section 3 clause 2 is more specific in nature, so that we can accommodate more offenses under this. Section 2 clause n specifically deals with it's more general, that all kind of contexts or behaviors comes under this, but section 3 clause 2 is more specific in nature, because more kind of offenses can be added to this provision. Any doubt regarding this?
No doubt.
Section 3, 2 clause n and 3 clause 2. Okay, thank you. Thank you, Sanskriti, for responding. Next, we will go deep into the manifestations of sexual harassment. That I have already mentioned. Section 3 and Section 2 clause N of the Act talks about definitions of sexual harassment, aspects, corresponding factors, primary factors. So, now we will go into the manifestations. That there are significant manifestations for sexual harassment in the work environment. First one is there should be an abuse of authority. I was giving examples or explanations by mentioning my superior authority, my superior authority. So from that, it's implied there should be an abuse of authority. That if I'm working as a subordinate and my superior is asking me to do some sexual favors so that he will give me any preferential treatment in the workspace, so that itself proves that because he is my superior authority, he has some powers over me. I mean career wise powers over me, so that he can abuse it. So that is the first manifestation of sexual harassment. First one is abuse of authority, which means that the person who has more power can demand by a person in authority for sexual favors in order for the victim to obtain any kind of job benefits such as increment, promotion, transfer, anything, but in favor of a sexual or in demand of a sexual favor. So that is first manifestation of sexual harassment, that is abuse of authority. Next is creating a hostile environment. So if a person is behaving in an unwelcome manner which involves any sexual conduct, but it results in a hostile environment where that particular victim is not able to work properly, or the peaceful environment is disturbed, and due to this sexual conduct, that can be called as a hostile environment. So creating a hostile environment is the second manifestation of sexual harassment. And third one is that retaliation or reprisal, which means that a person's future aspect is tampered, or the peaceful environment to work is disturbed, which means that needless gossips or tampering with evaluation reports, levying false charges on her. So all this comprises of a retaliation in the regarding the sexual harassment. So these are the three manifestations under section 3 of the act which talks about sexual harassment. So first one is abuse of authority, second one is creating a hostile environment, and third one is retaliation or reprisal. So next we are going to look about the some aspects regarding the sexual harassment. Do you all think that a single incident or a multiple incidents is necessary? What do you feel? Is it necessary that this thing should happen multiple times that a person can make a complaint?
No,
No,
a
no.
single time. I feel a single incident should be enough.
Yes.
Yes, single incident itself is enough. But if multiple incidents have occurred, what a person can do is that he can register the complaint by considering the last date of that incident. So we will go detail into it while considering or while talking about the procedural aspects. But I'm telling you, single incident itself is enough. Single incident is itself enough. No, frequency of the contact is not essential, or the frequency is not considered while ascertaining the or the depth of the the effect. So single incident itself is enough, and cyber harassment is also included. As I already mentioned, the mode of harassment is not, it doesn't matter whether it's physical, mental, online, offline, anything is considered to be a sexual harassment. What if a person is texting me daily or emailing me things which has sexual overtone? It is also considered as a sexual harassment. So cyber harassment is also included in this legislation. So I have covered the all the aspects of sexual harassment. If you have any doubt regarding this, you can ask at this point of time.